Now that everyone has calmed down a bit, let's look at yesterday's conviction of Donald Trump in more depth. Legal experts have questioned the foundations of the New York porn star case since the arraignment. To give you a little background, this current criminal case against Donald Trump in New York City is over a $130,000 payment made to a porn worker, Stormy Daniels. Michael Cohen, Donald Trump's former personal lawyer, pleaded guilty to multiple charges, including campaign finance violations, tax evasion, and bank fraud, in August 2018. Cohen testified that these payments were made to influence the 2016 presidential election and were directed by Trump as part of a catch-and-kill plan. Michael Cohen was prosecuted within the statute of limitations and plead guilty as part of a plea deal to flip on Trump and cooperate in other investigations. So prosecutors paid Cohen with a reduced sentence to testify against Trump. Cohen admitted to lying under oath in a 2019 congressional testimony and has lost all credibility for both his plea deal and his admitted perjury. Trump was charged with 34 counts of campaign finance violations, falsification of business records, and conspiracy, all predicated on Daniels' consensual encounter and payments that Cohen made to her and Karen McDougal, an ex-Playboy playmate. Both women testified that they had affairs with Donald Trump but have never presented proof. Neither woman has provided DNA or video evidence to substantiate their claims of having had sexual encounters with Donald Trump, and the evidence of an affair largely consisted of their own testimonies. No dirty or even suggestive communications exist between these women and Trump. The communications presented as proof are between Michael Cohen and Daniels' attorney, Michael Avenatti, both convicted criminals. So let's look at these charges based on this one payment, which was almost 8 years ago. But first, please share and like this video, and don't forget to subscribe and ring the bell for notifications of my new videos. First, campaign finance violations. In New York, the statute of limitations for campaign finance violations is 5 years. This means that charges for campaign finance violations must be brought within 5 years of the alleged offense. This is what prosecutors are trying to hang their hat on, and there are 3 hurdles I see. First, it's outside the statute of limitations. Next, there is no substantial evidence that Trump knew or reimbursed the admitted perjurer, Michael Cohen. And they must prove that even if Trump knew and reimbursed Cohen, and it wasn't outside the statute of limitations, that Trump's intent in doing all this was to influence the election and not protect his family. There are lots of reasons to turn this around on appeal related to whether it is prosecutable or proven. Next, falsification of business records. The statute of limitations in New York for falsification of business records in also 5 years. The allegations of falsification of business records stem from efforts to conceal the true nature and purpose of the payment to Stormy Daniels. Falsifying business records is a misdemeanor but can be elevated if intention of falsifying the records was to concealing a second crime. The prosecution alleged that the Trump Organization allegedly recorded reimbursements to Cohen's shell company as legal expenses. Additionally, it's alleged that these records misrepresent the true nature of the payments for tax purposes. Suspiciously, none of the 20 witnesses were from the IRS to testify to this effect, and the IRS never prosecuted Trump for tax violations in spite of the fact that he's one of the most audited people in the country. And lastly, conspiracy charges. In New York, the statute of limitations for conspiracy charges is also typically 5 years. This means that charges for conspiracy must be brought within 5 years of the alleged agreement to commit the underlying offense. The underlying offense of paying Stormy Daniels with alleged campaign money was nearly 8 years ago for a consensual encounter that happened 18 years ago this July. So this is strike 3 regarding anything legally prosecutable within the statute of limitations. This case was riddled with reversible errors according to experts. First, there's that fact that all alleged predicate crimes were expired according to the statute of limitations. Crimes that have passed their statute of limitations are generally not prosecuted because the statute of limitations sets a maximum time after an event within which legal proceedings may be initiated. Once the statute of limitations has expired, the crime cannot be legally prosecuted, making the percentage of expired crimes effectively 0. Second, there were significant conflicts of interest related to the presiding Judge Merchan. Not only is he a Democrat zealot, but his daughter raised $92 million for the Republican Party and received a $4 million payment from Democrat Adam Schiff, We're talking high stakes here, guys. I don't know about you, but $1,000 is a lot of money to me. I will likely not make $4 million in my lifetime, and we are watching our money, our future Social Security, education, and healthcare be whittled away by people who dismiss a $4 million payment from a vocal opponent of the defendant you are trying. And these people work for us. What's wrong with this picture? Next, we need to consider the fact that from the start, Judge Merchan denied Trump's request for a change of venue, knowing that there was no way he could get a fair trial in the strong blue state of New York City. So I need to ask myself, how can a group of jurors who hate you be a jury of your peers? But the bias didn't even begin at this point. Trump was under a gag order not allowing him to defend himself to we the people via the media. Also, critical witnesses to dispute the prosecution's allegations were barred. One of them was a records expert, and records violations were a critical part of the case. But that's still not it. There were numerous rulings that favored the prosecution, even to the point of allowing them to treat allegations as if they were fact in front of the jury. The jurors had to determine beyond a reasonable doubt that Donald Trump falsified business records with the intent to commit or conceal a conspiracy to unlawfully influence the 2016 presidential election. So it all comes down to proving intent beyond a reasonable doubt. Why did Trump pay off the two alleged concubines? Trump argued that the purpose of silencing Daniels and McDougal was to spare him and his family the embarrassment of public attention to alleged extramarital affairs, not to help his campaign. Since so many presidents have famously had affairs and even rape charges while in office, it follows that in reality, news of Trump's affairs would not have prevented the people from voting for him, especially since they were both admittedly consensual. But the embarrassment to his family and young child who he put under the spotlight by running for president could be a valid intention. So remember that. Everything in this case hinges on what Trump's true motives were when he agreed to pay off two women with unsubstantiated accusations. So I don't know if these people expect us to believe that we live in a world of thought police who can actually read our thoughts to know our intent. Although one of the major discrepancies is related to the jury instructions. Jury instructions are crucial in the legal process as they provide the jurors with a clear understanding of the legal standards and principles they must apply when deliberating on a case. These instructions guide jurors on how to interpret the law, assess evidence, and determine the facts, ensuring their decision is based on legal criteria rather than personal biases or misunderstandings. Properly crafted jury instructions help safeguard the defendant's right to a fair trial by promoting consistency and objectivity in the jury's verdict. They also aid in the appellate process by providing a documented framework of the legal context in which the jury reached its decision, which can be reviewed if an appeal is filed. The 55-page jury instructions for the Trump jury were anything but properly crafted. Judge Merchan actually read the 55 pages of instructions to the jury. They were not allowed to have a copy of the instructions. When they had questions, they had to request that the judge read that part of the instructions to them again. He read 55 pages, which they were supposed to remember. It doesn't seem fair to me that jurors couldn't have a copy of the judge's instructions, but this morning I found the entire 55 pages published on the New York Times and MSNBC websites. This is all so obviously unfair, and I will continue to publish the facts to help others understand what's going on. It is a particular part of these instructions that is making the hair stand up on the back of the neck of legal scholars. Follow me closely here. There could be no conviction of falsifying records unless Trump was convicted of one of the 3 predicate crimes of violating campaign financing laws, falsifying records, or conspiracy. The law requires a unanimous decision, but Judge Merchan instructed jurors that they did not need a unanimous verdict on the predicate crime. Some could vote for falsifying records, while others could still find him guilty of falsifying records or conspiracy. So the way the jury instructions were structured, there did not need to be a unanimous consensus of guilt of any of the predicate crimes in order to convict. This is just unheard of and completely bypasses the intent of a jury trial. The final conviction votes have not been released, and we may never know if the predicate crime was unanimous or not. These are just a few of the irregularities surrounding the recent Donald Trump hush money case. Most legal experts I've seen believe the case is reversible, and Trump has already vowed to appeal the convictions. Sentencing is scheduled for July 11th, just days before he is expected to be nominated as the 2024 Republican presidential candidate. this conviction does not preclude Trump from running for office or becoming the President of the United States. Don't be surprised if the sentencing imposed by Merchan makes it impossible for Donald Trump to campaign, either via incarceration or house arrest. Also, don't be surprised if Donald Trump is elected president in November. After his conviction, the Trump websites crashed from so many people trying to donate money to the campaign. In fact, Trump raised $52.8 million in the 6 hours after he was convicted. This newest corruption being exposed is called lawfare, which is using the legal system as a weapon. Trump is clearly a victim of this lawfare. We all better pray that it never happens to us.